Hello, and welcome to Let's Talk Immigration, episode 79. Um, what are we going to talk about? First of all, always open to your questions. That's why I'm here. So if you want to put your questions in the comments, they should come up here on my screen, and then I will address them. But first, I want to talk about an update that I should have caught last week, but I just now become aware of it. And that is the State Department has shared their mid-fiscal year 2024 visa milestones support U.S. economy and global ties, right? So this means that they are bragging about their achievements. So we're going to take a critical look at these achievements and see if they are as great as they say, okay? So, see, non-immigrant visas, they're talking about tourists and students, and that's great, but we've only got so many consular officers, right? So if they're doing tourists and students, they're not doing immigrants. They're not doing family-based, employment-based, and diversity visa immigrant visas. So when they lead with this, look how we got 5 million non-immigrant visas, mostly tourists, I'm just like, you're hiding something. So let's keep going. Let's scroll down to the bottom. Oh, immigrant visas. We mentioned immigrant visas. One of the first times the State Department's acknowledged that they even are involved with immigrant visas. Try to find Secretary Blinken acknowledging it. That's not going to happen. Anyway, it says here, this is immigrant visas too. Okay. Well, here, I'm going to skip to this part because it's the part I noticed first. In the first 6 months of fiscal year 2024, it says a quarter of U.S. embassies and consulates issued more immigrant visas by the fiscal year 2024 midpoint than in any prior year of the last decade. Okay, they're trying to sound awesome here, but what that means, first of all, they only went back a decade. So why aren't they looking at what happened in 2013? Maybe it's because they were doing a better job in 2013. Second, they're saying a quarter of the U.S. embassies issued more immigrant visas by the fiscal year 2024 midpoint. That means 75% of U.S. embassies did not even meet last year's production of immigrant visas. Okay. Well, maybe not last year's, but they didn't break records, which if you really want 2024 to be the year of the immigrant visa, like they told Ayla, although they didn't mention here, all embassies, not just 25%, would be breaking this little record. Okay. And this is a big tale. We issued over 152,000 immigrant visas to family members of U.S. citizens in the immediate relative category, an all-time high for the fiscal year mark. Okay, first of all, what they're talking about is IR1, IR2, and IR5. Spouses, minor children, and U.S. citizens. Spouses, minor children, and parents of U.S. citizens. Okay, this is leaving out all the family preference categories, like spouses and minor children of green card holders, or unmarried children of green card holders, or unmarried children of U.S. citizens, or married children of U.S. citizens, or sibling petitions. You know, they're leaving all that out here, and there's a reason, because that's where they are failing, and I've challenged that failing in lawsuit after lawsuit without the success that I would have hoped, right? So anyway, Blinken continues to neglect family preference category visas, isn't even mentioning them here on this webpage. One more thing. One of the reasons this is a record for immigrant visas is a lot of the family preference category visas that would have normally been issued became immediate relative visas. Let me tell you why. Green card holder petitions for spouse or children, minor children. The petition takes 5 years, and then they're eligible for citizenship. When they become a U.S. citizen, their petition for their spouse changes to IR1, which is an immediate relative category. So one of the reasons this number looks so good is because they're doing so bad. Right? Anyway, got that off my chest. Sometimes when people are bragging about how good they're doing, read really closer. Read closely. See what's really going on. That's my tip of the day. Okay. I think I'd rather just jump into questions now. Okay. Let's see if we got some good questions. If we don't, maybe they'll come. I need some good questions. I'm going to invite people backstage too to come on the screen and ask questions if they want. Sharing that link right now. I want to say to come to ask your question live on screen. And then I'm sharing the link, and that should go to YouTube, Twitter, and Facebook, I think. I don't know. Okay. So change my, here's the question. Hi, Curtis, DV 2021, good luck. Thanks for the commitment to on our case. How long does the courts take to respond on the Gomez case to speed up the appeal decision process? Okay, good question. Judges and courts have ultimate discretion over when they do what they do. So they could ignore that motion if they want to, or maybe they will give a decision soon on the appeal. I don't really think they would issue an order on the motion. Either they will issue the opinion sooner than they would have, or they won't. Okay, so we probably won't see an order that says, hey, this is what they're doing. Sergey wants to join us. Let's take a live person here. Can you hear us okay, Sergey?
Hi, how are you?
I am good. I see you are a Project Voyager client. You've identified yourself. Project Voyager is DV 2020 selectees who were not plaintiffs, but they are our clients. And they are Gomez class members.
Yes, of course.
Yeah. So do you have any question for us today, or are you just saying hi?
No, I was just having the question that last time you told us the Gomez class, and you just fired in Gareta for appeal court. Then to ask the court how they can just adjust the the decision of the appeal. So, do you expect any response from the appeals court in these days, or you don't know? You don't have any idea?
I don't have an expectation that they would respond to that motion. What they would do is either they're going to consider it compelling and we will see an opinion sooner, or they are not going to see it compelling and they will issue the opinion when they would have issued it normally. So I do not expect to see an actual order on the motion. I don't expect that would happen because that would waste their time. Instead of taking time to explain to us why the opinion's taking longer, I would rather them spend that time on the opinion. Right?
Okay.
I don't need an order on that motion. We need the final outcome is what we need. So to answer your question, I do not expect a response to the motion. Either it's going to influence them or it will not.
So it seems like the appeals court it is on the side of the government, because if you just count the years, it is like 4 years we are waiting for 2 years.
You know how the appeals court's on the side of the government? If they issued a one sentence order after the oral arguments that said the government, the district court decisions are overturned.
Mm.
I mean, they have deliberated about this for 2 years. That does not happen if they were on the side of the government. They would just agree with the government instantly. I think we have more reason to believe that at least one, if not two or three of the judges are sympathetic to our cause, our positions. Does that make sense?
Yeah, it makes sense, but there is also another question. But if we lose on this decision, if it comes, and I am seeking, do you expect it to do an appeal on the Supreme Court?
That is a difficult question because it depends upon the reasoning in the order. Okay.
Okay.
Let me give you an example. If they overturn our victories, but their reasoning is sound and they make very good arguments, well, then that's going to be that are the kind of arguments that the Supreme Court would be sympathetic to. That would make it more difficult for us to have a successful appeal. But if there's problems in the reasoning, well, then yes, we would be able to move forward with an appeal. But I can't make this decision on behalf of everybody. I would need to go back, kind of get a feel for what our clients would want to do, and also talk to the council, and they would talk to their clients for the other cases because we have all these consolidated cases, and it just makes sense if everybody agrees to do something and we do the same thing. But it's difficult to talk about hypotheticals like that because remember, there's multiple issues in the statement of issues for the appeal. Yeah. There's multiple issues that the appeals court is considering, and it's possible they could find where they agree with us on 2 of the issues and agree with the government on 2 of the issues, but it's okay with us. It depends. Depends on how.
Yes.
Just have to wait and see.
Yes, I think we are going to wait for the decision as well. As we are in limbo for 2 years, for 4 years, without doing anything, without just having something to do on the appeals. So,
yeah,
the last question I am asking for the project Voyager. So, what are you going to help us after the decision of the appeal when it is becoming positive as well?
I'm going to help you as I can. How I'm going to be able to help you, I don't know yet because I don't know what procedure that they're going to follow in scheduling those interviews and issuing those visas. It's not going to be like anything we've seen before because we know from the declaration that they filed with Judge Mehta about the IT system, the KCC will not be involved. It'll be between the embassies and the applicants, and hopefully their applicants and their attorneys, since we entered G28s for all of our clients, meaning we've let the State Department know that we represent you. So hopefully we'll be able to communicate with the embassies directly. I ran across this morning, yesterday actually, an email where we won a successful case called Young versus Trump. We won injunctive relief, and at the time, Christina Gazarian was an attorney that worked with us, and she had sent an email to an embassy with a list. These are all of our clients that need to be interviewed pursuant to this court order. And the embassy used it as a list to like check them off and responded to the list and said, okay, we've done them all. And we're like, thank you. So sometimes embassies will be very cooperative with us as attorneys. Other times they will ignore us. It depends. It remains to be seen how that will work.
Okay, let's wait and see what will happen in a few days.
What embassy were you supposed to be scheduled at? Remind me.
Kigali, Rwanda.
In Rwanda?
Okay. Yeah, embassy of Kigali.
Okay. Okay, well, thank you.
Do you think the embassy of Kigali are the smooth people, are collaborative? Because we just had some embassies that they don't respond to the emails as well. They don't just consider the representative like the attorneys. So
you know, that changes from year to year because sometimes the visa chief changes. He or she goes to a different assignment and they take a different policy. So we have had bad experiences with that embassy and we've had good experiences. It changes. Okay. So I would not presume that we're going to have a problem with an embassy before we do. I'm optimistic about that.
okay, let's wait and see. Goodbye, Morrison. Huh?
Goodbye, Sergi. Thank you for coming by. Bye. Okay. That was fun. Oh, this is a follow-up question to Vershawn's first question. Has there been a previous appeal case which take this long where attorneys have requested the courts to expedite the decision and there has been success going this route? I am not aware of a appeals case where attorneys were so bold as to ask the appeals court to accelerate their decision. I had a lot of reservation about us doing it. I know class counsel Jesse Bless did too. But ultimately, that's what everybody wanted to do. That's what the plaintiffs wanted to do. That's what Raphael wanted to do. And so we tried it with the district court. When the district court said no, Gomez class counsel said, let's ask the panel, the appeals panel. But no, there's not a history. That's not a regular procedure to poke the court and say, come on, we want a decision. We did it anyway because we have really compelling grounds to do it, right? Good cause, but it's not regular, and I can't point to another decision where it's happened before. Okay. Omar says, nice haircut. Thank you, Omar. You can thank Armando, who is cutting my hair now in our little village. Not bad for an attorney look. Thank you. Okay. How about 2021? 2021 is not my favorite year. I think you're asking about DV 2021 and without identifying whether or not you're a good luck plaintiff, and that frustrates me. Omar says, best legal advice for new immigrants to the U.S. Where to start? If you're young and you are required to do selective service, do not forget to do that because it can cause you problems with naturalization. Remember to always let USCIS know when you move. They want to know that for all lawful permanent residents. If they go to send you mail and you're not there, they will not forward it. What they'll do is they instruct the post office to return it to them so that they know that you're not complying with that rule and not letting them know where you are. So very important, if you're not a U.S. citizen, to always let USCIS know where you live. Okay. Another tip to make sure you get your green card is, and I say this all the time, take a little piece of paper and I don't know what a little piece of papers are. A little piece of paper, write your name on it, tape it to the inside of the mailbox to make sure that the mail person knows that you live there so that they don't send the green card back and you don't get your green card. It happens a lot. That's my advice. I have other advice, but just a little bit at a time, right? Mr. Morrison, any news for good luck plaintiffs? No. Still awaiting the outcome of the appeal. How about DV 2020? Still awaiting the outcome of the appeal. Let's see how many different ways this question can be asked. Let me see here. Take a guess. Hello, sir. If the judge orders the issue of the good luck visas before the presidential election and Trump won the presidential election, can he stop it? This is an interesting question. And the reason it is an interesting question is because the very issue, one of the statement of issues in this appeal is whether or not the State Department can interpret a presidential proclamation that bans the entry of foreign national under INA Section 212F can be used by the State Department to stop the visa issuance. So what the outcome of the appeal is actually impacts Trump's ability to throttle immigration. That's why I am so pissed at Biden and Blinken for not dropping this appeal. Because what they're doing is they're setting up a future Trump administration to be more empowered to throttle immigration than they even were the last time. Why would Biden do that? What is he thinking? This old man does not need to be our next president. Neither does Trump, but I'm just saying. I get frustrated on this particular issue. I'm not screaming at you. I'm screaming into the sky. Ahmed says, hi, Mr. Morrison. What about batch 2021? Okay. Ahmed, the majority of DV 2021 selectees, their journeys ended on October 1st, 2021. There are two subcategories that did not end, and you have not identified yourself as being a member of either one of them. One of them is good luck plaintiffs or go plaintiffs, and another one is DV 2021 selectees who were awaiting interviews at embassies in the Schengen area, Brazil, or China, and they are protected from Judge Chutkan's order in Ray. So without knowing which of these three categories you're in, like good luck or go plaintiffs are protected by Ray or other, I don't have a prognosis for you. Okay. And it's frustrating for me to explain that from a high level over and over and over when all you have to do is be more specific in the question. Omar says, in the past, you said one of the factors to get a visa is your embassy situation. That has not changed. So as always, after a new visa bulletin, new VB embassies, since 2NL every embassy, how we know our embassy for good enough for reserved visas, good luck. I do not understand this question because you're talking about the visa bulletin, VB embassies. Why would you talk about the visa bulletin for DV 2021 good luck visas? The visa bulletin will have nothing to do with reserved good luck visas. So, unless VB stands for something else. What's VB stand for, Omar? Waleed says, I'm one of the good luck plaintiffs. Still, I have hope to make it to the U.S. Waleed, I'm glad that you still have hope. I still have hope that you're going to make it to the U.S. too. So, that's great. Omar says, at least Trump withdraw the appeal, not like Biden. Omar references a procedurally correct point. When we won injunctive relief in the Gomez matter, Mohammed Thong John Kennedy, Aker, and Gomez, in early September of 2020, the Trump administration initially appealed that order, and then they dropped the appeal. They withdrew that appeal. Unlike Biden. Exactly. Thank you, Omar, for making that point. I feel like a lot of you probably agree with me when we're screaming, but we're screaming to each other. Like nobody's watching this video that works at the State Department. Our government attorneys, sometimes government attorneys probably watch these. I don't know. Bellardi says, hello, sir. I don't receive more emails from you. I'm from DV 2020. Any news about it? Well, if you did receive emails from me before in your DV 2021, it probably means you're a good luck plaintiff. And please reference that in the future because I don't email all DV 2021 selectees. The majority of DV 2021 selectees, their journeys ended on October 1st, 2021. However, they still come to me every day and say, are you sure? Are you sure? And the reason is questions like this, where good luck plaintiffs think that the relief was for all DV 2021 selectees. That's not the case. Okay. But you don't receive good luck. The reason good luck plaintiffs do not receive updates from me is because I don't have updates. And I think it is dumb for me to send emails that say I don't have an update. I think that people would get angry at me for that because they'd see an email from Curtis and they'd say, oh, this is good news. There's an update from Curtis. And they'd open it and I'd say, ha, psych, no update. I don't want to do that. When I have an update, I'll let you know. Emery says, hi, Curtis. Thanks for the live. I was wondering, is there any sort of priority involved in administrative processing of K1 compared to others like B1? Emery, the answer to that question is no. Administrative processing happens at the SAC office for immigrants and also K1s. They may handle them slightly differently because there's something called NVC that's not the National Visa Center, but the National Vetting Center that's under USCIS that will handle vetting for non-immigrant visas. But I don't think they handle the vetting for K1s. K1s, although it's a non-immigrant visa, it's treated like an immigrant visa at many of the stages and under the law. So it's a little hybrid situation. I agree that it probably should be. There should be some priority with that. I think that there should be some priority with all immigrant-based and K1-based vetting SAO requests, but I'm not in charge, so I don't get to set policy. Waleed said, is there any problem if we apply for a B1, B2 in the same time we are one of the good luck plaintiffs? No, there is not a problem. There is a question on the DS-160 that says, have you has anyone ever petitioned for you before? It's an ambiguous question, so I think you're okay with answering yes or no. But my recommendation is, my preference is that you say yes and say you were a DV 2021 selectee who is not issued a visa. There's no reason to mention a lawsuit. I have heard situations where DV 2020 or class members are good luck plaintiffs go into a non-immigrant visa interview, either for a visitor visa or a student visa, and they start talking about the lawsuit. Well, guess what? The goal of a non-immigrant visa interview, your objective is to convince the consular officer that you do not intend to use this visa to permanently reside in the U.S. If you're talking about a lawsuit that's important because you have a dream of permanently residing in the U.S., that situation undermines the purpose of your visit to the embassy that day. Okay, so I'm not saying hide or misrepresent your status as a plaintiff. You're not going to be asked about it. Just don't volunteer it. There's no reason to volunteer information at an immigrant visa interview that you're not asked about. I realize I'm not bullying you, by the way. I'm just elaborating on a related issue to your question. Waleed says, also, is there an advantage if we are in the USA as good luck plaintiffs? We do not know the answer to that, except under some narrow parameters. Okay. And the reason we do not know is we do not know if we win the appeal and we win summary judgment, whether or not those, instead of having a visa issued, you'll be able to redeem a green card under adjustment of status. The State Department and the Department of Homeland Security need to agree on that question, and they have not come to an agreement. And also they have deferred that decision. They're not going to make that decision right now because it might not be necessary for them to make that decision if they win the appeal. Okay, but there is a narrow situation where there is not an advantage, and I'm going to go ahead and tell you that because lots of people have found out the hard way. If you come to the U.S. at the southern border to seek asylum and you come in the U.S. without lawful status, you're not going to be able to deem reserved green card. The diversity visa lottery program is not set up for adjustment of status when you don't have status. The only way you can adjust status from the U.S. is if you have lawful status. So if you're in the U.S. on a student visa or a work visa or a visitor visa that's not expired, your time's not up, then maybe adjustment of status will be an option, but we don't know yet. But if you're not, if you just entered a different way, then adjustment of status, that ends your DV journey, is what I'm trying to say. Yeah. Not that that's what you were going to do, but okay. Omar says, my point was every embassy sends 2NLs for DV winners. How we know our embassy is good enough and we don't need to transfer our case when visas distributed. See my next text. Majority of embassies send 2NL, but how we sure it is good or not? Okay, so I thought a 2NL was an interview letter. So you're saying okay, this question you have about transferring is not timely. It doesn't make sense because you can't touch your case right now. It's frozen. So there's no transferring of cases. Let's say we prevail on the appeal and Judge Mehta says, okay, issue those visas. We do not know at that point whether or not the State Department's going to cooperate with us in allowing people to change their interview locations. And I may discourage it, actually, in some situations, because in some situations, you definitely want to do it. If you were assigned to Kabul, that embassy's not there. You definitely want to try to change your interview location. But what if the process of changing your interview location puts you at a disadvantage or puts you behind the line or something like that? So the decision about changing an interview location is sensitive, and I'm going to produce some more information about making that decision when it's relevant and if we know if it's an option. Okay, asking that information now. I understand why you want to know things in advance, but if I don't know them in advance, I can't share them. When I know them, I'll share them. Provided you don't kill me first, right? By asking me the same questions over and over. Anyway, Lamine says, hi, Curtis. When the appeal court will reply on the Gomez motion. That was addressed earlier, they might not. I think the way that they would respond is either they would find it compelling and issue the opinion sooner, or they won't find it compelling and they won't. I hope that they don't waste time that they could spend preparing the opinion by preparing a response for you to the motion. I don't need a response to that motion. I need the opinion. Hope that makes sense. Omar says a majority of embassies send 2NL, but now Omar, you're asking me hypotheticals based upon things we cannot know. Okay, we just have to wait and see. Francis says, hello, how about DV 2021? Okay, I've talked about DV 2021 for like the whole hour, so you can scroll back. Everything's clear. Omar, last thing as a plaintiff, I'm not agreeing if Judge Mehta agrees accepting new spouse or kids as plaintiffs because the number of visas is heartbreaking, but they have to accept it. So what he's referring to here, Omar's referring to here, is there's some ambiguity in both the Gomez and the Good Luck order about whether or not new spouses and children who are arguably not Good Luck plaintiffs or Gomez class members, whether they will have paths to immigrate with the primary applicants. I think there's an argument to be made on both sides, and we don't know how the government will interpret that. When I say there's ambiguity, there's places where Judge Mehta referred in his orders to the people that benefit from this order as selectees, which was not precise because spouses and children of selectees also should be able to benefit from this order. So we just have to wait and see how that's interpreted. I wouldn't say like heartbreaking, and I would say like extremely inconvenient. Okay, because let's just say you won, you were a good luck plaintiff and you were single, but since then you've got married and you have 2 kids. Well, if you're issued a visa, you could come in the US, and once you have a green card, you could petition for your spouse and your 2 children. It's going to be an F2A application, and it'll probably take 3 to 5 years, but there will be a path to your family immigrating to the US, which would be huge in the lives of your children, right? Even though it sounds like an almost impossible and ambitious path, it is a path that many immigrant families take, where the winner, either male or female, comes to the U.S. first, sets up camp, files a petition, and brings the rest of the family in time. It's hard. I'm not saying it's not, but that's a path. Okay. Hello, Mr. Morrison. We are Santee. I do not know what Santee means. Santos versus Biden. Okay. This is a lawsuit that was dismissed by Judge Kogan over a year ago. Category F4. Okay. Siblings of U.S. citizens. We got our passport with visas last month. Finally, right? We are coming to the U.S. When I say finally, they were plaintiffs in 2 lawsuits. Jacob lawsuit filed in January of 2021, and then the Santos lawsuit filed in California, and then the Santos lawsuit filed in New York. So it's crazy you had to be plaintiffs in 2 lawsuits, and you're just now coming to the U.S. Okay, I have mailed you. Check kindly. Okay, when you say mailed, I hope you mean to email, and I try to get through all my emails every 24 hours. So if I see that email there, I'll respond to you. Thank you for remembering me. Okay, Omza says, thank you, Mr. Morrison. What about DV 2021? Okay, I'm going to answer Omza's question, and then I'm going to call it a day. Omza, the majority of DV 2021 journeys ended on October 1st, 2021. The journeys that continue are only the journeys for Good Luck and Go plaintiffs and DV 2021 selectees who are waiting on interviews from embassies located within the Schengen area, Brazil, or China. If that's not your situation, your DV 2021 journey ended on October 1st, 2021. Okay. Goodbye, everybody. Adios. Have a good day. See you next week.